How should I pronounce it from now on?
Put that accent over that E.
All right. I think that's an opportunity.
Yes. All right. The court is calling 2025 CR 0044180 State versus Diana Lacante. Could I have parties announce?
Rick Pena for the state of Texas.
Nick Aguilar on behalf of the Honorable Diana Lacante.
And how do you pronounce your last name? Lacante. All right. There's no. All right. You're not Jordan. She's not from Louisiana. Okay.
Well, she says she is.
Oh, yeah.
It's not the correct pronunciation. What is your family doing?
He's over there.
Mom. Come on, Mom. Teach you. You have to teach. Oh no! Don't come forward. Yeah, you got to teach your daughter better with the pronunciations. No. Yeah. Let me just tell you, we're off the record.
How should I pronounce it from now on?
Put that accent over that E. All right. So we're back on the record. Counsel, have you received all the discovery in this case?
Yes, Your Honor.
And did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. And is there an application in this case?
Yes, Your Honor. This should be up there. I found it in my notes.
All right. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Buckle up, because this case is not what it seems on the surface. Today, we're diving into the courtroom drama of State versus Diana Lacante, a controlled substance felony case that quickly turns personal, revealing not only the defendant's struggle with addiction, but also her entanglement in an abusive relationship. There's mispronunciations, surprising humor from the bench, and a plea deal that could change everything. But wait until you hear how the court rules and the emotional moment where Diana opens up about her past. So the big question is this just another plea deal, or is the justice system offering a second chance? Let's break it all down. And stick around for the judge's unique twist on community service, because you won't believe what gets offered instead of 150 hours of labor. This is one courtroom roller coaster you won't want to miss.
And sign it.
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, you're proceeding on the indictment as presented, correct?
Yes, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand your charge of possession of a controlled substance, penalty group 1 gram to 4 grams as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with, why are you putting citizenship Louisiana on this paper?
I always do that, Judge, just so the judge knows I asked. Always put in state.
Okay, all right.
When you see that, you'll see it on all my. I always make a note there so they know I asked.
Oh, okay. I was like, are you just doing that?
Another country. Lafayette.
Lafayette, okay.
You know where that's at.
All right. Did you understand by entering this plea, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Very much so, yes.
Do you believe she's currently competent and is legally sane at the time of the offense?
Yes, Judge.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
Okay. According to the plea, punishment is to be assessed at a $2,000 fine. The state is recommending deferred adjudication. and there's to be restitution for drug testing. Did you understand that to be the plea?
Here's where things get serious. The defendant, Diana, is charged with possession of a controlled substance, penalty group 1, between 1 to 4 grams. That's a third-degree felony in Texas. The punishment range? Anywhere from 2 to 10 years in prison and up to a $10,000 fine. But the judge is exploring a plea agreement that includes deferred adjudication, a kind of probation where if Diana complies with all the terms, she won't have a final conviction on her record. This is huge. It gives her a chance to rebuild her life. What do you think? Should a first-time offender battling addiction get this kind of opportunity? Or should the court crack down harder? Let us know in the comments.
Oh, well, let me go over it. So, according to your plea bargain agreement, there's a $2,000 fine.
Yes.
The state is recommending that you be placed on a form of probation that's called deferred adjudication. Did you understand that?
Yes.
And they're asking for restitution, and the restitution is supposed to be for the drug testing. Do you understand?
Yes.
They don't have an amount for the drug testing because it's not in the police report how much it costs to test the drugs. Do you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, were there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. At this time, state offers into evidence, state exhibit 1 with all attachments.
All right, state, you may be excused.
Thank you, Your Honor.
Judge, we have no.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
This is the emotional crux of the entire case. Diana's lawyer reveals she was trapped in an abusive relationship and she turned to drugs to cope. Her admission that she did about 100 drugs may sound vague, but the subtext is clear. She was self-medicating through trauma, and the courtroom's tone shifts. Suddenly, this isn't about just a substance charge, it's about survival. The defense asks for compassion through deferred adjudication. And here's the kicker. Diana has never been in trouble before. What would you do if you were the judge? This is the turning point, and it shows how deeply personal justice can become.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. All right, proceeding with sentencing.
If you would consider that this afternoon, Judge, yes.
All right, anything you wish to say on behalf of your client?
Judge, Diana was in an abusive relationship. She admits that she did one of the drugs in her stock. She tells me she was self-medicating to help her through the relationship she was in. She's never been in trouble before that I'm aware of. So it took a bit to get through to understand the deferred concept, deferred adjudication supervision concept. But she would like you to consider granting her the deferred adjudication for a period of 4 years.
All right, are you employed?
Yes.
What do you do?
I'm a sales agent
And what are you selling?
from Spectrum. Spectrum.
Spectrum.
Spectrum.
Yep.
Okay. Spectrum does keep going up on their prices. Nobody knows. They get you in with the contract and then prices rise. So I've heard. How long have you been working there?
I just started, it's my 4th week.
The last time we were here in quarantine, we got out of here quick so that you could get her orientation that was.
All right. And how many children do you have?
3,
What are their ages?
25, 22, and 17.
All right. And do they still live with you?
No,
Okay. Where's the 17-year-old? Who's he with?
he's with his dad.
And if you're drug tested today, well,
Now, this is not your standard sentencing. The judge lays out the terms $2,000 fine, probated, 4 years of deferred adjudication, and 150 hours of community service. But then, an unexpected twist. The judge offers parenting classes as a replacement for community service. That's right. Take the classes, and your 150 hours are considered complete. It's a bold move. Instead of labor, the court prioritizes rehabilitation and life skills. This moment isn't just legally significant. It's human. It's the justice system trying to heal, not just punish. Would you take the classes, or sweat it out in the Texas heat? The judge's tone is tough, but fair. And honestly, kind of brilliant.
the result's going to be.
I'll pass.
Hmm?
I'll pass.
When's the last time you used?
4/20, 2024.
Okay. All right. This is what the court is going to do. There's a $2,000 fine. That will be probated. 4 years deferred adjudication. 150 hours of community service restitution. And you know what? Even though he's 17, I'm going to ask for the parenting classes. You can never go wrong with the parenting class. Once you complete the parenting classes, the 150 hours of community service restitution will be deemed satisfied. Now, if you don't want the parenting classes, your other option is to work in the Texas heat for 150 hours.
Yeah, I don't mind classes either.
Okay. So there has to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. Do you have to go to work today?
Oh, yes.
Okay. Then we'll do a UA tomorrow. There'll be field visits 1 time per month for 4 months. TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient treatment, we can start with intensive outpatient treatment.
I did all that. No, I did
Hmm?
patient, I did outpatient.
Oh, just give that information to them. Okay. But what the TAP evaluation is, it's just some questions you need to answer and they'll make a decision. They may say you don't need anything. All right. All right. Probation. Is there anything else? Is there anything else you need from the court in order to be successful?
Just a question if I can take the UA today.
The court doesn't just hand out freedom. There are layers of accountability here. Diana must report regularly, provide proof of employment, avoid working around minors, and undergo random drug tests. The TAP evaluation will determine if further treatment is needed. But notice this, Diana asks to take her drug test today, to avoid missing work tomorrow. That's a small but powerful sign. She's taking this seriously. This isn't just about obeying the law. It's about climbing out of addiction, 1 test, 1 check-in at a time. And the judge? Clear and firm, but encouraging. It's a reminder. The system works best when people are ready to help themselves.
That way I don't have to miss tomorrow too.
Sure, you can take a UA today. All right. Anything else?
Will somebody give her guidance on where to take that UA?
Yes. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right. We can go off the record. In this court, communication is key to be successful on probation. If you have an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to the court. All right. All right. Good luck to you.
Thank you so
All
much.
right. You're welcome.
Thank you, Judge.
All right. Bye-bye. Mick, you were great as far as the testing.
I think I'm going to be fine today.
Yes.
Thank you, Judge.
You're welcome.
So what was the proper pronunciation?
Let me just tell you.
was put the state, sometimes the city, up
Mhm.
where you saw it.
Yeah.
That way they look down and know I asked.
Yeah, because let me just tell you, that is always, that's the first time I've seen that. So that's why I was like, LA, what?
We put it there just so that they can look to say, okay, he talked about it.
Mm-hmm.
Thank you, Judge.
All right, thanks. Have a good one. Yes. I don't know. I'll have to look and see. Yeah, just give me a moment.
So here's the bottom line. Diana Lacante pled guilty to felony drug possession, but walked away with a second chance through deferred adjudication. The court considered her past, her willingness to recover, and structured a sentence that balances consequence with compassion. Parenting classes, regular check-ins, no shortcuts. This case shows the justice system isn't always black and white. Sometimes it's about what lies in between: accountability and redemption. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more real cases, real drama, and real justice coming your way.